By the time I reached the ridge above the subdivision, the last roof was already going on. 96 houses. Fresh streets. New mailboxes. Concrete driveways. Backyard fences. Porch lights waiting for families who had no idea they were moving onto land that still had my name on it. I stood there with the deed folder under one arm and watched workers finish a place that should never have existed. That was the strangest part. Nobody was hiding. The HOA signs were up. The model homes were open. A sales banner moved in the wind like everything below me was lawful, settled, untouchable. If you didn't know the boundary lines, you would have believed it too. That was exactly what they were counting on. They thought construction was proof. They thought time could erase paper. They thought once enough walls were standing, nobody would dare pull the whole thing apart. So I let them keep building. I let the roads get paved. I let the closings start. And when the HOA president smiled at me and said I was too late, I almost smiled back. Because I wasn't late. I was waiting for the courtroom where the deed would finally speak. My name is Cole Mercer, and the reason I did not panic when I saw those houses on my land was simple. I had already known for weeks. Not every detail. Not every poured slab or utility trench. But enough. Enough to understand the line they had crossed. Enough to know the developer and the HOA were building with the kind of confidence people only have when they believe nobody dangerous is paying attention. The dangerous part was not anger. It was patience. My family had owned that acreage long before the subdivision existed. Before the decorative stone entrance. Before the glossy mailers promising country living with modern amenities. Before the HOA started acting like every piece of open ground near its fences was future community space waiting for permission to become theirs. The parcel sat along the west side of the development, mostly flat, partly wooded, with an older survey line that developers kept pretending was unclear because the truth was inconvenient. It was never unclear to me. My grandfather had walked that line with me when I was 12. He showed me the markers, the creek bend, the old iron pin near the cedar break, the fence post that no one touched without our say-so. He used to tell me the easiest land to steal is the land people stop looking at. That line stayed in my head when the first grading equipment showed up near the ridge and started carving roads where no road should have been. At first, I thought it was another bluff. The HOA had tested boundaries before. Trail language. Access questions. Shared edge nonsense in board packets. But heavy equipment is different. Concrete is different. Once they started pouring foundations, I stopped treating it like overreach and started treating it like evidence. So I documented everything. Dates. Photos. Drone shots. Survey overlays. Tax records. Every new house made the file stronger. That is what most people do not understand about land fights. They imagine the smart move is to run in early and start shouting at bulldozers. Sometimes it is. But sometimes the real leverage comes later, when the mistake is too big to dismiss as confusion and too expensive to bury under apologies. By the time I stood on that ridge with 96 houses below me, I was not looking at a surprise. I was looking at proof that the people running that HOA had confused speed with ownership, concrete with title, and momentum with law. And that confusion was about to cost them more than any of them were ready to imagine. The first sign they knew exactly what they were doing was the speed. This was not some confused contractor pouring one slab a few feet over the line. This was organized. Fast. Roads cut in sequence. Utility trenches laid clean. Foundation forms stacked in rows like they had been planned months in advance. Somebody had approved plats, signed off on grading, and pushed crews forward with the confidence of people who believed land becomes yours the moment enough machines start moving across it. The HOA president fed that confidence every step of the way. Her name was Dana Whitmore, and she carried herself like the whole west edge of the subdivision already belonged to her future newsletter. Perfect jacket. Perfect smile. Perfect tone. She never talked about the parcel the way a real property person would. No legal description. No deed reference. No track number. She talked about it like a lifestyle brochure. Expansion opportunity. Community phase. Future shared amenities. That was how she sold the lie. If you said those words often enough, people stopped seeing dirt and started seeing destiny. I met her once, early on, before the first row of houses went vertical. I drove out to the site after spotting survey flags too far west, climbed out near the grading line, and asked the foreman who had authorized work across the Mercer boundary. He pointed me toward Dana before he answered a single question. That alone told me what kind of project this was. She walked over smiling like she was greeting a difficult neighbor instead of a landowner standing on his own acreage. She said the subdivision had every right to continue. She said their maps were clear. She said if I had concerns, I should bring them to the association after construction review was complete. After construction review. That phrase stuck with me. It meant delay. It meant confidence. It meant she thought a finished neighborhood would become its own legal argument. I asked her if she had checked the deed. She said the developer had handled the title side. I asked if she had seen the county survey overlay. She said the board was comfortable with the boundary interpretation. Comfortable. Not certain. Not recorded. Not lawful. Comfortable. That was when I understood what made this so dangerous. Dana was not acting from proof. She was acting from momentum. She believed every poured curb and framed wall made her stronger. She thought the longer the project ran, the less anyone would challenge it, because the human instinct is to protect what already looks complete. So I stopped trying to win the argument in the dirt. I started preparing to win it where paper matters more than houses. So I let them build. That sentence sounds crazy to people who have never watched bad faith dress itself up as progress. They hear it and think weakness. Delay. Fear. They imagine I stood off to the side while strangers hammered nails into my land because I did not know what else to do. It was the opposite. I knew exactly what I was doing. Stopping them early would have turned the whole fight into a local dispute. A shouting match at the grading line. A developer claiming map confusion. An HOA president talking about permits, misunderstanding, and working toward resolution. They would have called it messy. Technical. Premature. Maybe they would have paused one section, redrawn another, and spent the next year trying to bleed the truth into something negotiable. I did not want negotiation. I wanted certainty so large it could not be hidden inside polite language. So I documented every phase and said very little. I tracked the first paved road. The first utility box. The first closed sale sign. The first family moving furniture through a front door built on acreage the county record still tied to Mercer land. Every milestone made the case heavier. Not emotionally. Legally. Because a mistaken fence line can be argued around. A poured subdivision cannot. Once streets exist, once homes are marketed, once buyers sign papers, the lie stops being theoretical and becomes a chain of liability with names, dates, and signatures attached. Dana never understood that. She saw my silence and mistook it for surrender. Every time we crossed paths near the West Ridge, her confidence got cleaner. She started talking like the outcome had already blessed her. She would gesture toward the rooftops and say things like, "It's far too developed to revisit now," or at some point, "Reality matters more than old paperwork." Reality. She meant visible reality. Finished walls. Families. Curbs. Mailboxes. The kind of things that make ordinary people feel like the land beneath them must already be settled, because who would build this much if it were not? That was the trap she trusted. She believed concrete creates legitimacy. I believed records survive concrete. And every day those houses stood there, my position got quieter and stronger at the same time. Not because the land changed. It never did. But because the scale of their mistake kept growing until no judge in the world would be able to look at it and call it confusion. By the time the last roof went on, Dana was smiling like she had won. I was waiting for the courtroom. The lawsuit started quietly. No dramatic press release. No angry post online. No threat dropped at the sales office in front of buyers. Just a filing, clean and precise, with the deed, the survey, the tax parcel history, and the construction footprint laid beside each other in a way no amount of Dana's confidence could smooth over. That was the first real moment the project became dangerous for them. Before that, it was still a development with momentum. Trucks moving. Closings scheduled. HOA packets printed. Landscaping crews planting the future like it had already been approved by God and county records alike. But once the case number existed, every house sitting on that west tract stopped being a symbol of success and became what it really was. Exposure. I remember the first time Dana realized it. She showed up outside the site office with a copy of the filing in one hand and that same polished expression she always wore when she was trying to stay above a situation that had already reached her throat. She asked me, almost like she still believed she was the reasonable one, why I would endanger 96 families over a map dispute. A map dispute? I nearly smiled. Because even then, even with attorneys reading the deed and surveyors marking the line in language her board could not decorate into something softer, she still needed the story to sound small. A map dispute sounds harmless. Temporary. The kind of thing sensible people settle over coffee and compromise. A deed dispute is different. A deed dispute means one side owns the ground and the other built anyway. I told her that if she wanted to know who endangered those families, she should start with the people who sold homes on land they never owned. That was the first time her face changed without recovering quickly. Not collapse. Just a flicker. A thin fracture in the expression. Because she knew the truth was starting to move out of meetings and emails and into the one place she had never really planned for. Discovery. Depositions. Survey testimony. Recorded history. The boring, merciless machinery of a courtroom where nobody cares how finished the houses look if the title underneath them belongs to someone else. And standing there beside the sales office, with fresh sod being rolled out behind her like somebody was still trying to beautify a mistake. Dana finally looked less like a woman running a neighborhood and more like a person hearing the first real crack travel through something she thought was already permanent. After the filing, the whole development started moving like a body that had just realized it was injured but had not yet decided how much pain to admit. Sales did not stop immediately. That was the strangest part. The sign stayed up. The model homes stayed open. Trucks still came and went. Contractors still hammered, painted, poured, and patched as if routine itself could drown out the legal fact sitting underneath every finished driveway. From the outside, it looked like nothing had changed. That was exactly what Dana wanted. If buyers kept showing up and lawns kept going green, maybe the lawsuit would feel abstract long enough for everyone to keep pretending the West Tract was only a technical issue. But inside the offices, the tone had changed. I knew it because people who had ignored me for months suddenly wanted meetings. The developer's attorney called first, asking whether I would consider practical resolution options in light of the number of families already under contract. Practical. Another soft word. The same kind Dana loved. A word meant to move the conversation away from ownership and toward inconvenience, as if the main problem here was not that they built a neighborhood on my land. But that cleaning it up might now be difficult. Then the HOA's counsel reached out. Different tone. More careful. He asked whether my position was really that the entire western phase sat across the Mercer boundary. I told him my position was whatever the deed, survey, county parcel map, and construction overlay said it was. Nothing more. Nothing less. He went quiet after that. That was what documents do in situations like this. They take all the heat, noise, urgency, and human pressure and reduce it to one unbearable question. Who owns the ground? Once that question hardens, everything else starts bending around it. Mortgage lenders get nervous. Title people get louder. Board members stop smiling in public. Buyers start hearing the word litigation. And Dana, who had spent months treating visibility like victory, suddenly found herself inside a problem no amount of finished siding could beautify. I heard from one contractor that crews had been told not to discuss the lawsuit with residents. Another said supervisors were now photographing lock corners before every shift. Even the landscapers had started checking staking marks twice, which would have been funny if the whole thing had not been built on someone else ignoring those exact details when they mattered most. That was when I understood the development had crossed into a new phase. Construction was still happening. But certainty was gone. The first real panic did not come from Dana. It came from the buyers. Up until then, most of them had been living inside a story carefully built for them. New homes. Fresh streets. Clean paperwork. A polished HOA welcome packet waiting on the kitchen counter. Whatever legal noise existed around the edges of the development probably sounded distant, technical, and temporary. Developers are very good at making unfinished risk look like someone else's paperwork problem. That illusion started breaking the day one couple knocked on my ranch office door. They were young. Tired. Still wearing the strained, hopeful look people carry when they have spent too much money on a house they are trying very hard to believe will become home. They told me the title company had contacted them about an active boundary dispute involving part of the western phase. Then they asked me the question everyone else in the development was about to start asking. Is our house on your land? I did not answer with emotion. I pulled out the parcel overlay, the recorded boundary, and the construction footprint. Then showed them the section where the line cut clean through what the developer had been marketing as a finished neighborhood phase. No drama. No speeches. Just paper. The kind that does not care how excited someone felt at closing. The woman sat down before I told her to. The man kept staring at the map like if he looked long enough the line might move out of mercy. That meeting spread faster than any court filing had. By the end of the week, more residents had questions. Some came quietly. Some called. Some sent angry messages through attorneys. Not at me. At the people who sold them certainty on land they never should have been building on in the first place. And that was when Dana's real problem finally surfaced. She had spent months pretending the finished houses protected her. Now the finished houses had witnesses inside them. Families. Mortgage holders. People with moving trucks, children, deposits, insurance forms, and every reason in the world to care about what sat under their foundation. That changed everything. Because board drama is one thing. Residents can ignore that for years if the landscaping looks good and the dues stay predictable. But once homeowners start asking whether the dirt under their kitchen island legally belongs to someone else, HOA confidence stops sounding like leadership and starts sounding like fraud. And Dana, for the first time since the first grading equipment rolled onto my land, was no longer dealing with a quiet ranch owner on a ridge. She was dealing with 96 households who suddenly needed the truth more than they needed her story. By the time the second round of buyer calls started, Dana had stopped pretending the lawsuit was just a technical nuisance. Now she was in containment mode. Emergency board emails. Closed-door meetings. Soft language sent to residents about title clarification, survey overlap, and temporary review of Western Phase records. She was trying to shrink a structural disaster into a paperwork delay. Because that was the only move left when the houses were already standing and the deed was older than every sidewalk in the subdivision. It did not work. People can live with uncertainty when it sounds far away. They stop tolerating it the second it reaches their mortgage, their driveway, or the bedroom their child is already sleeping in. The Western Phase homeowners were no longer asking whether the HOA had good intentions. They were asking who knew the boundary was wrong when they knew it, and why nobody stopped construction before families signed for homes sitting on land the county still traced back to my name. That was when Dana called me herself. Not through counsel. Not through the board's polished legal voice. Directly. She said the situation was becoming disruptive for residents and that I needed to consider the human cost of pressing the case this hard. I let her talk. That was always the easiest way to hear what mattered. She never once mentioned the deed. Never once said the houses should have been built somewhere else. She only talked about consequences now, which told me she had finally understood the point too late. Finished homes did not erase ownership. They multiplied the damage. I asked her one question. When did you first realize the West Line might be wrong? She went silent. Not angry silence. Careful silence. The kind people use when they know the true answer has already become dangerous. Then she said the board had relied on development materials in good faith and that revisiting old assumptions would not help anyone now. Old assumptions. There it was again. The same weak phrase people reach for when the records do not love them back. I told her assumptions were what got 96 roofs poured on somebody else's acreage. Then I hung up before she could ask for mercy in a softer tone. 10 minutes later another homeowner was at my office door, holding closing papers with both hands and looking far more frightened than angry now. The homeowner at my office was a man named Trevor Hale, and he looked like he had not slept properly since the first letter from his title company arrived. He held the closing packet in one hand and a printed copy of a neighborhood email in the other. The packet had tabs sticking out of it. The email had Dana's name on the bottom and one of those bland HOA subject lines designed to sound reassuring while people quietly panic. Clarification update. Review ongoing. Community guidance. The usual poison dressed as professionalism. Trevor did not waste time. He asked me straight out whether his house sat on my land. I told him yes. Not because I wanted to hurt him. Because lies were how the development got this far in the first place, and I had no interest in joining the tradition just because the human cost had finally become visible. He looked down at the parcel overlay I slid across the desk and followed the boundary line until it cut through the western phase exactly where his street began. Then he asked the second question. Did they know? That one mattered more than the first. Because ownership explains the problem. Knowledge explains the blame. I told him I could prove the deed, the survey, and the build footprint. What I could not yet prove, not completely, was the exact day every person involved understood the line was wrong. But I already had enough to know this was not some innocent mistake that survived one bad map and disappeared the second real paper showed up. There had been too many chances to stop. Too many letters. Too many flags. Too many moments where someone could have said, "Hold on, this parcel isn't ours." Trevor sat there in silence for a while, staring at the map. Then he said something that told me the whole development was about to turn in a way Dana could never control again. They told us the lawsuit was just a delay tactic. I nodded once. Of course they did. Because that is what people say when the truth is too expensive to explain plainly. They make the person with the deed sound unreasonable. They make patients look hostile. They make ownership sound inconvenient. Anything to keep buyers calm long enough for the next closing to finish and the next mortgage to lock. Trevor folded the email in half, then in half again, like he was trying to make the word smaller with his hands. When he looked up, the fear had not left his face. It had changed shape. It was no longer fear of me. It was fear of the people who sold him certainty on land they may never have had the right to sell at all. I'm tightening this section around the moment the buyer panic turns into courtroom pressure, and I'm keeping it locked to the exact word count. By the time Trevor left my office, I knew the next stage of the fight had already started. The lawsuit was no longer just me against a developer and an HOA president with a talent for confident lies. Now it had buyers, lenders, title companies, and residents inside it. That changed the weight of everything. Not the deed. The deed had been heavy from the beginning. What changed was the number of people suddenly forced to care about it. And when more people care, panic starts looking for somewhere to land. The first sign came from the developer's attorneys. Their tone changed overnight. The soft language disappeared. No more practical resolution options. No more talk about neighborly compromise or avoiding unnecessary disruption. Now they wanted emergency meetings. Fast document exchange. Immediate survey comparison. They started using phrases like exposure, reliance, title impairment, and temporary occupancy risk. Real words. Expensive words. The kind people only use once they understand the problem is no longer abstract. Dana kept trying to sound calm in public. That was almost painful to watch. Her emails still talked about ongoing review and community stability, but the room behind those words had changed. You could hear it in every message. Shorter sentences. Fewer promises. No more easy confidence about the Western phase. She was not managing a project anymore. She was standing inside a collapse and hoping careful language would make the walls fall slower. It did not. Because once lenders and buyers start asking whether homes were built on the wrong land, the story stops belonging to the HOA. It moves into records, escrow files, title commitments, and courtroom calendars. That was the shift I had been waiting for from the start. Not because I wanted people frightened. Because I needed the truth to become too large for Dana to keep framing as a technical misunderstanding. So I kept preparing. I updated the construction timeline. I labeled every photograph. I matched each lot footprint to the survey overlay. Then I placed the original deed, the certified parcel map, and the surveyor's affidavit in one clean trial folder and set it on my desk. 96 homes were already standing on my land. Sooner or later, somebody in a courtroom was going to open that folder and realize the houses had never been the strongest thing in the case. The paper was. And paper does not blink first. Court did not feel dramatic at first. That was the strange thing. After months of noise, letters, meetings, sales pressure, and HOA language stretched over bad facts like a cheap tablecloth, the courtroom itself felt almost insultingly plain. Wood benches. Fluorescent light. Quiet voices. Folders stacked where lives had already started bending around the contents. No cinematic thunder. No last-minute confession. Just a room where paper finally outranked confidence. Dana was there with the board attorney and the developer's team, still dressed like control belonged to her if she wore the right jacket and sat straight enough. But even from across the room, I could see the difference. She was not carrying the same energy she had on the ridge or beside the sales office. Back then, concrete had been on her side. Finished houses. Fresh roads. Families moving in. That visible momentum had made her bold. Court took all that away. In there, walls were just walls. Roofs were just consequences. And title was either yours or it wasn't. When my attorney called me forward, I carried one folder. Not the whole file. Not every photograph, email, and buyer message I had spent weeks collecting. Just the documents that mattered most. The deed. The certified parcel map. The surveyor's affidavit. The construction overlay showing where the western phase sat after completion. The judge looked at the deed first. Then the map. Then the overlay. No rush. No flourish. Just the steady attention of someone used to hearing expensive people argue around obvious things until a document finally corners them. The developer's attorney tried the same lines I had heard from Dana for months. Long-standing assumptions. Community reliance. Completed construction. Buyer hardship. Good faith boundary interpretation. Every phrase sounded weaker in court than it ever had in the field, because none of it touched the one question that controlled the room. Who owned the ground before the first foundation was poured? My attorney answered by sliding the survey beside the deed. The line matched. The tract matched. The legal description matched. And once those three things were sitting side by side under courtroom light, the whole story the HOA had been telling for months stopped looking complicated and started looking reckless. I glanced at Dana then. For the first time since this started, she was not trying to look composed for the people around her. She was staring at the deed. The judge did not say much at first. That was worse for them. People imagine courtroom reversals as loud moments. Objections. Gasps. Somebody collapsing under the weight of a lie they can no longer hold upright. Real damage is often quieter. A judge reading a deed twice. A finger pausing on a parcel number. A second look at a survey line that keeps landing in the same place no matter how expensive the houses above it were. That was the kind of silence filling the room now. The developer's attorney tried to shift the ground again. He talked about reliance interests, good faith development, substantial completion, public impact, practical hardship. He said tearing apart a built neighborhood over a boundary error would create chaos for dozens of families who bought in honestly and had no role in the original mistake. He was not wrong about the chaos. He was wrong about the boundary error. An error is what happens when someone misses a fence by inches or pours a driveway over the line before anyone notices. 96 homes, paved roads, utilities, and sales closings do not happen by error alone. They happen because enough people keep moving after the warning signs appear, each one trusting the next person to be the one who actually checked. My attorney stood, asked for permission to present the timeline exhibit, and walked the court through it slowly. Original deed. Recorded tract history. Certified survey. Flagged construction dates. My first written notice. The developer's continuation. The HOA letters. The buyer closings. And finally, the board meeting packet where Dana had still been talking about community interpretation after the county description had already cut straight through her story. That was when the judge looked up. Not at me. At Dana. And asked the question that had been chasing her since the first day she stood on the ridge and acted like progress could replace title. When did the association first receive information that this land might not belong to it? The room changed again. Not because anyone answered quickly. Because no one could. Dana's attorney touched her sleeve, but the damage was already there. The question itself mattered more than whatever careful response came next, because it moved the case out of abstract land law and into knowledge. Timing. Responsibility. Who knew enough to stop and kept going anyway? Dana cleared her throat. The developer's counsel shifted papers. My attorney did nothing at all. He did not need to. The deed was already on the stand. Dana did not answer the judge directly. That alone was devastating. Not because silence proves guilt by itself. Because silence, in a room where deeds, dates, and warning emails are already lined up like fence posts, starts sounding less like caution and more like memory choosing the safest place to hide. The judge gave her a second to respond. Then another. The developer's attorney leaned in, trying to redirect. Dana finally said the association had relied on development materials and believed the western phase was being built within the approved footprint. Believed. There it was again. The same weak word she had hidden behind at the ridge, at the sales office, and in the board meeting. Believed when she wanted momentum to sound innocent. Believed when concrete sat where title should have mattered more. Believed when 96 families were told the ground under them was certain. My attorney asked permission to introduce the county correspondence. The judge nodded. He handed up the email chain, the parcel confirmation, and the surveyor notice that had been sent before the final phase was completed. Not after. Before. Clear language. Clean records. Enough to stop any honest project in its tracks. The judge read the date. Then looked back at Dana. This time the silence in the room felt different. Heavier. Sharper. No longer waiting for clarification. Waiting for responsibility. Because once the warning date existed, the whole development changed shape in the eyes of the court. It was no longer just a finished neighborhood sitting on the wrong parcel through bad luck and bad maps. It was a neighborhood that kept moving after someone had reason to stop it. After someone had been told the line might not be where the HOA wanted it to be. Dana's lawyer started arguing that the association itself did not control construction sequencing and that the developer bore primary responsibility for any continuation after notice. The developers' counsel immediately pushed back, saying HOA approval packets and Western phase representations influenced buyer confidence and marketing language throughout the build-out. For the first time since this started, they were no longer standing together. They were dividing blame. And that was the moment I knew the deed had done exactly what I wanted it to do. It had not just proven ownership. It had broken the alliance that let all of them move in the same direction while the houses went up on my land. Once the developer and HOA started blaming each other in open court, Dana lost the last shield she thought the finished neighborhood gave her. That was the real break. Up to that point, she could still pretend she was part of a larger machine. A board president. A community representative. One voice inside a complicated process where everyone relied on everyone else and nobody could be expected to carry the full weight of 96 homes standing on the wrong land. That illusion only worked while the room accepted the idea that all mistakes had been shared. The deed changed that. The warning date changed it more. Because once the court had both, the story stopped being about confusion and turned into something much harder for Dana to survive. Knowledge. Timing. Choice. Someone had reason to stop. Someone kept moving. And the more the attorneys tried to spread the blame across contractors, developers, approvals, and interpretation, the more obvious it became that Dana had done what she always did. She used confidence to carry a weak claim farther than proof ever could have. The judge asked for a recess after the last set of exhibits went up. That was when the room changed again. Not emotionally. Structurally. Developers stopped looking at Dana like an ally. Buyers who had come to watch stopped seeing the HOA as a protective layer between them and the mess. Even the board attorney had shifted in his chair in that careful way lawyers do when they can feel the client becoming harder to defend with every minute that passes. Dana sat there with both hands on the table, eyes fixed on nothing. No more polished half-smile. No more neighborhood confidence. No more body language built for newsletters and meetings. Just a woman staring at the cost of believing a finished structure could outrank a recorded boundary. When court resumed, my attorney did not need to perform. He simply walked back through the chain one last time. Deed. Survey. Warning. Continued build. Buyer reliance built on false certainty. HOA language amplifying a footprint the association had no title to claim. Then he sat down. The judge looked over the file, over the exhibits, and finally across the room toward Dana and the developer's team. He said the completed homes did not erase the landowner's rights. He said scale did not cure trespass. He said reliance created hardship, but hardship did not transfer title. That sentence settled over the courtroom heavier than any argument had. Because for the first time since the first foundation was poured, the most important thing in the room was no longer what they had built. It was where they built it. When the hearing ended, nobody walked out like they had won. Not the developer. Not the HOA. And definitely not Dana. That was the strange thing about real collapses. They do not always look dramatic in the moment. Sometimes they look quiet. Paper being gathered with shaking hands. Lawyers speaking in low voices that used to sound confident and now sound careful. Buyers standing in the hallway with their faces drained, finally understanding that the polished neighborhood they were sold had been built on a mistake too big for landscaping to hide. I stepped outside the courthouse with the same folder I carried in. The deed was still inside it. The same deed they had treated like an old piece of paper until it stood up in court and turned 96 finished homes into evidence. That was the part Dana never understood. She thought the houses made her strong. She thought streets, porches, and families moving in would scare me into compromise before the truth had to stand under fluorescent light. She thought a finished development would feel more real than an old legal description written long before her HOA ever started mailing welcome packets. But ownership does not care how complete the siding looks. It does not care how many lawns were seeded. It does not care how expensive the mistake becomes after people keep building on top of it. By the next week, the fallout started moving faster than the construction ever had. Emergency settlement talks. Title panic. Residents demanding answers. Board members turning on Dana in private first, then in public. The same people who had smiled through sales brochures and phase maps were now asking the only question that ever mattered. Who let this happen after the warning came in? Dana lost the room before she lost anything official. That always comes first. Once nobody trusts your certainty anymore, the title on the letterhead becomes decoration. The homeowners knew it. The developer knew it. Even her own board knew it. She had turned momentum into arrogance, and arrogance into exposure. As for me, I never needed to shout. I never needed to stop the framing crew with a dramatic speech or stand in front of bulldozers to make a point. I let them build because every poured slab made the lie heavier. Every closing made the record sharper. And when the right room finally opened, I let the deed do what it had been waiting to do all along. They put 96 homes on my land. I pulled one old folder open in court. And suddenly, all their concrete looked temporary.